So, of course, the Mississippi Girl had to pick an Elvis song. But truly, we are caught in a trap, and we can't walk out because we love you too much, baby. So, when the Supreme Court a few years ago issued the Daimler opinion, defendants celebrated everywhere. But now we're a few years into the litigation, and we're seeing some unexpected consequences and encountering some unknowns as a result. There are circuit splits regarding consent statutes, differing opinions on how these decisions affect class actions and mass torts, and there are numerous questions surrounding jurisdictional discovery issues. So despite wanting to jump on the jurisdictional motion bandwagon, we must proceed with suspicious minds. We must look at numerous ramifications and consequences, such as allocation of fault, discovery, possible judges, evidentiary standards, punitive damages, exclusion of experts, and all of this is juxtaposed with the need to file your jurisdictional motions quickly or the issue will be waived. So, life before Daimler, jurisdiction was boring, black and white. Poor Elvis had kind of a sad childhood, it looks like. There was no glitter or fascination with jurisdiction. In fact, often defendants didn't even look into jurisdictional issues because it was usually a no-win situation. Most courts followed the traditional three-pronged test. The defendant must have sufficient minimum contacts. The claims asserted against the defendant must have arisen out of those contacts, and the exercise of jurisdiction must have been reasonable. However, this was kind of a moving target and varied tremendously among the jurisdictions. Life after Daimler. Jurisdiction is like flashy, kind of like Elvis's bedazzled jumpsuit. They breathe new life into jurisdiction. I remember when an associate came in my office right after Daimler, and he was so excited. He was like, this is going to turn jurisdiction on its head. And I really was concerned because I was like, you should not be this thrilled about jurisdiction. However, he was actually very, very correct, and life has changed. Now we look at the defendant's actual contacts with the forum. Did that give a rise to the claim? Or, for general jurisdiction, where's the defendant at home? Which has pretty much been clarified as principal place of business, the place of incorporation, or an exceptional case. And BNSF Railway went further to say a corporation that operates in many places can scarcely be deemed at home in all of them. So this is what we did as defendants after Daimler. We were dancing a jig. But maybe we didn't have reasons. It's kind of like the Ole Miss fan. That's Fred Krutz, our founding partner. Many Ole Miss football fans don't get to dance a jig anymore either. And we're realizing now that as defendants, there are issues that we still have to contend with, even though we won the jurisdictional opinions. As the dust settles, there are new issues that make us realize it's still not walking on easy street for all defendants. Now, Daimler did actually bring about a domino effect to litigation. It was a major change. Textbooks had to be rewritten. Defendants who had previously not contested jurisdictional issues had to look at their numbers, their data, prepare their employees to answer certain discovery issues. And all of a sudden, we realized that we had to look at each complaint the minute it came in for certain jurisdictional issues. There are still questions, though, that remain, including the consent-based jurisdiction. There's a circuit split on whether or not a state statute requiring a business to register to do business is enough to infer that they consented to jurisdiction. 38 states have rejected this notion, basically saying those are the type of theories that were so grasping and exorbitant that Daimler overruled. 4 states, though, have said, yes, this is enough. And in 8 states, the issue is still unclear. Practically speaking, the Second Circuit said it best when it said that if mere registration and the accompanying appointment of an in-state agent without an express consent to general jurisdiction nonetheless suffice to confer general jurisdiction, every corporation would be subject to jurisdiction in every state in which it registered. Thus, Daimler's ruling would be robbed of its meaning by a backdoor thief. Another issue that we are still kind of grasping with and dealing with is jurisdictional discovery. There's no doubt that Daimler and its progeny balance the scales of jurisdictional issues, but we must still proceed with caution. Justice Sotomayor noted in her concurring opinion that the majority's approach in Daimler will also lead to greater unpredictability by radically expanding the scope of jurisdictional discovery. This must be examined before filing your motion to dismiss, because applications of discovery rulings are often haphazard and defendants are at the mercy of individual judges. This is an unknown in federal courts because the recent amendments to the federal rules limited the scope of discovery by not only allowing for the usual relevancy test, but now there's a balancing of other concerns, like the weight of the issues, the scope of the questions, how much the discovery will cost, and the accessibility of the information. Depending on what court you're in, though, if you're in state court and have a judge who is notoriously known to allow for broad scope of discovery, putting your head out of the sand for a motion to dismiss could actually damage your client in the long run. For the most part, there are three different ways courts address jurisdictional discovery. First, there's a presumption that the plaintiff is entitled to jurisdictional discovery as long as the jurisdictional issue is not frivolous. Second, in some jurisdictions, the plaintiffs must satisfy a defined jurisdictional burden before being allowed to conduct jurisdictional discovery. And lastly, some circuits give lower courts discretion to determine the availability of jurisdictional discovery. This creates a situation where it's important not to overlook the forest for the trees. Is it worth filing a motion to dismiss in light of the risk associated with jurisdictional discovery? Will your client have to produce a witness or documents that might harm your overall defense strategy? As defense counsel, we must prepare our clients for potential fishing expedition, have accounting departments, tax departments ready to provide financial data, and actually you have to have a potential 30B6 witness ready to go. Are you going to produce discovery in this initial stage of litigation that has far-reaching implications? Are you drawing premature attention to your client? And be wary of those far-reaching implications. The uncertainty is a concern for discovery-sensitive corporate defendants with numerous cases across the country. Finally, did Daimler upend years of class action practice? In BristolMyers Squibb, Justice Sotomayor's dissenting opinion expressed a concern that the holding could result in piecemeal litigation and make it impossible to bring a nationwide class action in state court against defendants who are at home in different states. There's a circuit split on this. So in a recent federal district court for the Western District of Virginia, the defendant argued that the court lacked personal jurisdiction by stating BristolMyers was a seminal case that revolutionized class action practice. The court, however, stated that it did not believe that BristolMyers Squibb upended years of class action practice. Instead, the court explained, as most of the courts have countered this issue, that BristolMyers Squibb's holding and logic do not extend to the federal class action. Other courts have found that the BristolMyers decision does bar the exercise of personal jurisdiction over claims of a non-resident class member against non-resident defendants. Some courts have found that nothing in BristolMyers suggests that it does not apply to named plaintiffs in a class action. Rather, the court announced a general principle that due process requires a connection between the forum and the claims at issue. But what we're seeing more so in my practice, and what's really become an issue, is parallel litigation that is common in mass tort cases. So pre-Daimler, basically all the defendants, 50, 60 defendants would have been brought in one suit brought by one plaintiff. And there wouldn't have been any jurisdictional arguments. But now we're seeing defendants named an initial suit in a jurisdiction that isn't great but not terrible. We participate in the litigation, and then suddenly a co-defendant may file a motion to dismiss for lack of jurisdiction. They get out, the plaintiff refiles the same litigation against that defendant in the proper jurisdiction, and then dismisses other defendants and renames them in the suit that's pending in state B. This creates a unique situation because we still have cross claims pending in the original case, and we're still participating in the second case, and the plaintiffs are getting an unfair advantage in this way. Literally, in some situations, we're going out of the frying pan and into the fire. To allow plaintiffs to proceed with these parallel actions gives plaintiffs an unfair advantage because they get multiple opportunities at every stage of litigation, including multiple judicial rulings on motions and discovery issues, multiple trials on the same issues, and potential double recovery. In addition, defendants are not allowed to put on evidence in some states if other potentially negligent entities are not a party to the case. At the same time, these defendants are unable to access all potentially liable parties for purposes of allocation of fault and litigation of cross-claims because the court lacks jurisdiction over these parties. This is such a new problem, and there's still so many unknowns that we aren't sure how to proceed. The following legal arguments have been filed in several cases, and it's one option to circumvent these situations. You have to look at, do sufficient grounds exist for filing a forum nonconvenience request for dismissal in subsequent court? Does a jurisdiction recognize a first filed rule? Does a jurisdiction have an entire controversy doctrine or something similar requiring the litigation present all aspects of the controversy in one legal proceeding? There is a little opportunity to recover some money, though. Show me the money. We can potentially file a Rule 41D motion for recovery of cost if the plaintiff voluntarily dismisses you from one action and later refiles. However, there's a circuit split on whether attorney's fees are included as cost, but the purpose of the rule is to prevent forum shopping and other conduct by the plaintiffs, and some courts have said that's enough. Even if the statute doesn't specifically allow for recovery of attorney's fees, if the conduct is so bad and so obviously a forum shopping mechanism, they will allow attorney's fees to be included in these recovery of cost. So as a conclusion, the grass is not always greener. We have to be wary when filing a jurisdictional motion to dismiss, because you have to think about it's moving fast, you've got to do it quickly before it's waived, but yet you have to balance it with the possibility of a lot of jurisdictional discovery that could cause problems, a potential 30B6 deposition. And what if you are in a court where that's not going to be limited? What if you have a judge that is going to allow a broad scope for that 30B6 that may be taken in the first 6 weeks of the filing of a complaint? You have to balance the negative consequences with the positive aspect of getting out of a case that you don't belong in. But if you do get out, where might you end up? And so you have to look at multiple jurisdictions at the first phase of your litigation. And you have to be wary that plaintiffs are slowly figuring out how to handle this and are manipulating different forum shopping, not through jurisdiction now, but through other means. Thank you.